Hello everyone. I am Lee-Jung-ah. I will serve as a moderator. I'm also working as an activist. I'd like to welcome you to Parallel Session 5 on Disability Rights and UN Complaint Process as part of the 2022 PyeongChang Disability Forum. Thank you for joining us. First, let me introduce the three speakers. First of all, we have with us Ms. Ellen Clifford from Disabled People Against Cuts from the UK. And second, we have Stephen Allen, Co-Executive Director of Validity Foundation. And the third speaker is Liu Da-seol, Director of International Relations in Minbyeon, Lawyers for Democratic Society. And we have three panel members. First of all, Kim Sung-yeon, Director of Disability Discrimination Active Solidarity in Korea, and Cho Kyu-bum, Team Leader at the National Assembly Research Service, the Legislative and Judiciary Team. Last but not least, An Eun-ja, Director of the National Human Rights Commission of Korea, Disability Rights Division 1. Before we begin the session, I'd like to describe the situation. In 2007, Korea ratified the Convention on the Rights of Persons with Disability, and after 13 years, Korea submitted the optional protocol to the National Assembly, and it is actually approved by the President's office, but the National Assembly has postponed the ratification of the optional protocol by a year. So we need more support and movement to get through this ratification. Let's first go into the first presentation. We're providing simultaneous interpretation in Korean and English. So I hope that you will speak slowly for the sake of interpretation. Presentation will go on for 15 minutes, and the panel discussion for each is 8 minutes. And we have Lee Ho-jung and Jin Seon-mi as sign language interpreters. The first presentation will be provided by Ellen Clifford, who is an activist at the Disabled People Against Cuts. So please welcome her with a big round of applause.
Thank you so much, Chair. Firstly, I'd like to say how honoured I am to have been invited to speak to you today, and I hope you've all been having a great day so far. So as the Chair explained, my name is Ellen, and I'm speaking to you today on behalf of Disabled People Against Cuts, DPAC, or DPAC, as we're known, about our experiences of triggering a special inquiry under the optional protocol of the United Nations Convention on the Rights of Disabled People, or UNCRDP, as I'll call it. DPAC is a campaign group led and controlled by deaf and disabled people in the UK. Sorry, I'm just trying to change my slides here. It's not quite moving. I'll continue with the presentation and just read to you my script because my slides don't seem to be working. So to start with, I wanted to say a quick word about what we call devolution. Devolution is where certain powers have been devolved to the national governments of Scotland, Wales and Northern Ireland. Not all powers have been devolved to all nations, however. So Westminster has kept some powers over each of the nations, and it's different for each country, which makes it really confusing, which is something that the UN Disability Committee really hates. I also thought I should quickly explain some of the terminology that we use in Britain, as it's slightly different to disabled people's movements in other countries. So we say deaf and disabled people, not people with disabilities. And that's in line with what we call the social model of disability and the cultural and linguistic model of deafness. The social model of disability is fully in line with the human rights model that underpins the UNCRDP. And according to that social model, disability is a form of socially created oppression that society imposes on us on top of our bodily and or mental impairments and or differences. Thus, we're disabled by society, and hence we're disabled people. And in Britain, we also draw a clear distinction between what we call deaf and disabled people's organisations, or DDPOs, which are organisations fully run and controlled by deaf and disabled people, and non-user-led organisations that seek to speak for us. Article 33 of the UN CRDP places special emphasis on the importance of engagement, specifically with organisations of rather than for. So I'm here today representing DPAC, and we were set up out of a protest that happened in October 2010. As a campaign group, we have no paid staff or contract funding, but our founding members all came from DDPO backgrounds, and so our campaign is rooted in a social model and human rights approach. We were set up in direct response to the political economic situation that happened from 2010 onwards, that's disproportionately, adversely impacted on deaf and disabled people. So in Britain, to give the context of where we're at regarding deinstitutionalisation, so since the 1980s and early 1990s, most deaf and disabled people have been living in the community with access to direct payments from local government to pay for our own personal assistance to provide our independent living support needs. But institutions still remain. It's still legal to forcibly detain and treat people under the Mental Health Act in psychiatric facilities. There are also still a number of secure units for people with learning difficulties and autistic adults labelled as having challenging behaviour, and our government has missed successive targets for deinstitutionalisation. So the UK population of deaf and disabled people is around 14.1 million, and we still have almost 2,300 inpatients who are still in institutions, and we want them out as soon as possible. Most people, as I say, live in the community, but the disability unemployment gap remains huge, and most people, or many of us, rely on income from the social security system. So that's the context. From 2010 onwards, deaf and disabled people then faced an onslaught of attacks on our living standards through a programme of austerity measures and benefit changes disproportionately affecting deaf and disabled people. And people found themselves hit from all sides by multiple cuts and changes. Research found that disabled people were hit 9 times harder than non-disabled people by the cuts. But for disabled people with high support needs, that figure rose to 19 times harder. But the government hid what they were doing to the general public. They claimed to be protecting what they called the most vulnerable, and justified the cuts by saying they needed to fix a broken welfare system that was beset with fraud. According to their own figures, disability benefit fraud was very, very low, whereas they were seeking to cut the benefits by as much as 20%. And what they were actually doing was making the poorest in society pay for the financial crash. But as a consequence of their rhetoric, disability hate crime and hostility grew. And so more than a decade later, what we have is a benefit system where death has become an everyday part of it. We've had numerous deaths and suicides after wrongful cuts to benefits. Being disabled has become a full-time job, where there are endless reassessments, where people have to prove continuously that they're disabled through inaccessible assessment processes. There's rising poverty. Disabled people of working age are 3 times as likely to live in severe material deprivation than non-disabled people. Independent living support is ever diminishing as local government makes cuts every single year. And many disabled people have become trapped in their own homes, having to go without support for hours and hours at a time without access to food or drink or able to use the bathroom, and without support to ever leave their own homes. This has led the UN committee to talk about institutionalization in people's own homes, so that where a person's living arrangements takes on the characteristic of an institutionalization in terms of having no support, no choice and control, that constitutes institutionalization just as much as living in a big setting. Cuts are leading to resegregation, and because of the lack of support at a local level, people with higher level needs are now being placed in institutions, new institutions that are now being built miles away from their homes. Our government is now investing more and more in special schools, and so places in mainstream schools are diminishing for disabled people. Deaf and disabled people are becoming shut out of society again, and charities are taking over speaking for us as older, more experienced campaigners are dying out and the younger generation have reduced life chances. So this is the context in which we decided to use the optional protocol under the convention. Deaf and disabled people have been using every campaign tool in the book to try and, if not achieve reverses of the cuts, to at least slow them down, including legal challenges, raising awareness, lobbying Parliament, protests and direct actions have probably been our most successful way of doing that to raise public attention. But using the optional protocol was another way that we sought to approach this. It was actually the idea of the DPAC co-founder, Debbie Jolly, to try and persuade the UN Disability Committee to hold their first ever special inquiry under the optional protocol. It took about 3 years of sending evidence to them to persuade them. They were very nervous about it. They'd never done it before. Everything had to be top secret because they were worried about a diplomatic incident. But they did decide to go ahead with the inquiry, which they decided to focus on just 3 articles, Articles 19, 27 and 28. They visited the UK, they met over 200 witnesses and studied over 1,000 pages of evidence. And finally, in November 2016, they published their report, which found that the threshold for grave and systematic violations had been met. The following year, 2017, was the routine examination, which had been delayed. Our first examination under the CRDP had been delayed because of the inquiry, and that of course looked at every single article, and again the findings were very, very damning, and as a result of that the UK government has had to report back to the UN Disability Committee every year since. The government's initial response to the inquiry findings was to completely dismiss it. They tried to get their allies in the media to discredit individual members of the committee, which the committee was quite shocked by. It was quite difficult to persuade portions of our country that enjoy more wealth that what was happening was actually human rights violations in this country. That poorer people tend to be, well, disabled people we're congregated within the poorer income deciles within society, and there is a disconnect between our lives and those of people who tend to be wealthier and have more power in the country and don't get to see how disabled people live our lives. So some people just couldn't believe that this could be true. And in our country, the CRDP isn't enshrined in domestic legislation, so there were no real consequences for the government of the findings. But I would say that it was useful, definitely. Word did spread among our networks of solidarity that had built up over the years of campaigning against austerity and through social media. The investigation findings led to an unprecedented public and political profile for the convention, and all opposition parties have now pledged to enshrine it in domestic law if elected. Scottish and Welsh governments, and this is where we get to the importance of devolution, Scottish and Welsh governments are looking to put the convention into their own laws, as is the region of Greater Manchester in England. And Scottish and Welsh governments have also implemented some of the recommendations from the committee. Definitely deaf and disabled people in the devolved, in Wales and Scotland anyway, seem to have it a bit better. And evidence that we collect for the shadow reporting is always useful for lobbying. It definitely validated deaf and disabled people to feel that they'd been heard, having experienced being dismissed by their own government so many times. Being listened to is so important. It gives people hope to carry on. The government here hasn't been able to get away as much as it wanted to because of the way we have been able to raise public awareness of the reality of what's happening, and that means lives have been saved. To minimise reputational damage, our government, while carrying on with the cuts in this country, they did fund work to implement the UNCRDP in the Global South, and that's definitely a good thing. And deaf and disabled campaigners here feel a responsibility that the government here was once known as a world leader in disability, and if they start to move backwards and regress, that sends a very dangerous signal to other governments around the world. We need global deinstitutionalisation, and we don't want regression in our country to spread and prevent progress in other countries that may be further behind overall in their deinstitutionalisation programs. So it was worth it, although it was a lot of work. Finally, a few things I'd say to consider if you're thinking of doing like we did and trying to use the optional protocol. I'd say to be prepared for what will happen if your government won't listen, to make sure that you have media allies lined up, that you have networks within wider civil society, that you can get a real movement behind the issues that you're pushing with an optional protocol, to try to make the best use of what political allies in the election cycles that you can, and to plan ahead for how to respond to any attempts to discredit findings by the committee that aren't convenient for the government, but also to remember that you have international allies and don't be frightened to ask for solidarity. We are very happy in England to do things such as go and hold protests outside your embassy in London, if that will ever help you promote your own campaigns. So thank you for inviting me.
Yes, there was a lot of applause coming from the floor, I should say. Thank you very much. We were able to hear of the situation in the UK, how you were calling for a special investigation, a special inquiry into the optional protocol. We would try to do the same inquiry using your tips, maybe use the election cycle and etc. These are very realistic tips that you've given us. Thank you very much.
Let's move on to the second presentation. In 2021, in December, the UN committee took an investigation based on the Convention Against Torture. So a cruel treatment was recognized by the committee, and there was a series of court rulings against cruel treatments in certain housings. So we are going to learn more about a specific case in Slovakia, which will be presented by Stephen Allen from Validity Foundation. Please welcome him with a big round of applause.
Good morning, friends and colleagues. It's a real privilege and honour to join you all today, and particularly to support again the call for strengthened implementation and enforcement of the Convention on the Rights of Persons with Disabilities and other human rights standards in Korea. Indeed, I've had the honour of speaking at some previous events in your country over the last couple of years, and I can only say that I am deeply inspired by the leadership and activism of persons with disabilities across Korea. Indeed, your activism is also inspiring our efforts back here in Europe and more widely. Let me also start by warmly congratulating you all on the recent proposal of the National Assembly of Korea to proceed with the ratification of the optional protocol to the CRPD. I know it has been a long route and a long road for you all to follow. Today, I'm joining you actually from Geneva in Switzerland, where we are currently in the midst of an ongoing session of the CRPD committee. And of course, I'm very lucky to be able to spend time with the representative of Korea, Ms. Myung Kim, among other experts of the committee this week in fighting really for greater recognition of the rights of persons with disabilities. Let me start by saying that I work for a relatively small organization called the Validity Foundation, which is a specialist legal advocacy non-governmental organization headquartered in Hungary. And while we are based in Budapest, we work right across Central and Eastern Europe, as well as across Africa. And our primary mode of action is taking strategic litigation to advance the standards set out under the CRPD and other human rights documents. And in particular, we are focused on tackling large-scale institutionalization of people with disabilities, fighting torture and ill treatment, including disability-specific forms of torture and ill treatment, and promoting the rights to legal capacity and independent living. So my organization and colleagues fully support the paradigm shift that has been ushered in by the CRPD, and this demand to move away from charitable and medical models. We passionately support the call to recognize dignity and autonomy of persons with disabilities, regardless of their impairments or the level of support they may require to exercise their rights. We are no longer simply talking about social justice and equity. Instead, today, the debate has more fundamentally shifted in favor of enforcement of binding rights and obligations upon states, including through the courts where necessary. Nevertheless, let me note that the old medical model runs deep in many of our countries, and discriminatory attitudes against persons with disabilities in Central and Eastern Europe in particular remains all too common. Institutionalization from birth is still often regarded as the only option for people with disabilities. Mothers and fathers are told that if they do not put their child with disabilities into institutions, they can say goodbye to a career. They can say goodbye to their families and communities who are neither willing nor able to support them. And I'm afraid this deep form of social segregation is reinforced by strict guardianship regimes that strip the right to legal capacity from people with disabilities, facilitating their placement in institutions and facilitating their forced treatment, including forced psychiatric treatment. Now, let me note that the optional protocol to the CRPD, as you know, provides a crucially important additional tool to people with disabilities in Central and Eastern Europe and elsewhere by creating two unique international complaints mechanisms, whereby violations can be addressed directly to the committee sitting here in Geneva. Individual communications enable individual citizens to bring their own complaints about violations of their rights when they have exhausted domestic procedures and remedies. So far, the committee has considered 34 individual communications under this procedure, addressing issues as varied as social protection and assistance, non-discrimination at work, the accessibility of the banking system, and complaints about discriminatory rules denying people with disabilities the right to serve as jurors. Secondly, and as you've already heard from the UK, there is also the possibility for the CRPD committee to address what are called grave and systematic violations of the convention under the inquiry procedure. This is a particularly powerful route to challenge widespread violations of rights, and by its nature is designed to place a piercing spotlight on systemic problems that affect large numbers of persons with disabilities, or indeed particularly marginalized populations within countries who experience multiple and intersecting forms of discrimination. So you've already heard today about the committee's first inquiry in the UK, and to date the committee has in fact conducted 3 inquiries, the second in Spain and the third in Hungary. Most recently, as you've heard, in 2020, the committee published its report into the third inquiry concerning Hungary, which was a procedure that was triggered by my organisation. In brief, this third inquiry considered violations of Articles 12 and 19 of the Convention, concerning in particular the right to legal capacity and to independent living in the community, as well as looking at the principles of equality and non-discrimination. The wide-ranging investigation also looked at the particularly serious issues faced by children with disabilities, as well as women with disabilities. Despite being one of the first countries in the world to ratify the CRPD in 2007, my organisation requested the intervention of the CRPD committee in Hungary due to the persistently high rates of institutionalisation and guardianship, which collectively restrict the lives, autonomy and dignity of tens of thousands of persons with disabilities across the relatively small country. With a population of around 9 million, we can say that over 85,000 people with disabilities remain condemned to living the rest of their lives in institutions, and between 50 and 60,000 people remain under guardianship orders that deny them even the most basic rights to make decisions in their lives. These numbers haven't decreased at all since ratification of the convention, and if anything, these systems of segregation are being expanded, a matter that I'll address a little later in this talk. The issues in Hungary run deep in that they are reinforced by old and enduring discriminatory attitudes about the position of persons with disabilities in our societies. Those attitudes predate, in many cases, the transitions to democracy that have occurred in this region. Resources, and by which I mean financial resources, are not the main issue here. Hungary is an increasingly prosperous country that actually benefits from vast sums of development aid assistance from its membership to the European Union. But as the inquiry report on Hungary really shows, the country has chosen a seriously incorrect path over recent years, maintaining its defence of guardianship as a misguided form of care and investing huge sums of EU aid in increasing and expanding the system of institutions in the country. Dear friends, the CRPD committee took our concerns seriously and also conducted a visit to Hungary in 2019. Members of the committee met with hundreds of individuals, representative organisations, family members, and representatives of state authorities. They directly visited some of these newly built institutions, including the famed small group homes that are now mushrooming up across the territory. The final report is meticulous and damning, finding that Hungary's approach to reform of the system has failed and that its deinstitutionalization strategy shouldn't even have that name. It found the country responsible for grave and systematic violations of the rights of both adults and children with disabilities and demanded immediate remedial actions by the state. The committee has also urged Hungary to understand the historical significance of these findings, calling for the provision of reparations and other forms of compensation to all those who have been affected. As I mentioned earlier, Hungary also benefits from vast sums of EU funds, including in the fields of social protection. Importantly, the committee found that Hungary was using this money to finance human rights violations instead of promoting genuine progress. My organisation have been aware of this problem for over a decade, but we were consistently ignored, including by representatives of the European Union. I should point out at this point that the EU itself is also a party to the Convention on the Rights of Persons with Disabilities, and I believe that this issue will be taken up in a constructive dialogue soon with the Union. Let me also mention here something of the political context in Hungary. Unfortunately, you might know that civil society space has been under serious threat in this region in recent years, the victim of rising populist and nationalist rhetoric that portrays external actors as a threat. In practice, this means that there are few people who stand in solidarity with organisations of persons with disabilities in Hungary and who have the ability to speak out clearly against policies and practices which violate rights. Hungary has a policy of public admonishment of organisations and individual activists with disabilities who speak out. They place formal and informal pressure on civil society, including the withdrawal of funds and the threat of civil and even criminal prosecution. In this context, I cannot tell you how important the inquiry procedure was in providing a powerful and important international mechanism through which the voices of systematically silenced Hungarians with disabilities could finally be heard at the international level. Now, it's important to note that Hungary was only, the report on the inquiry concerning Hungary was only released into the public domain during the early part of the pandemic. Unfortunately, this reduced the immediate impact of the findings, with the majority of public attention diverted to responding to the public health emergency. Nevertheless, Validity and our partners have proactively publicised the findings, including by translating the report into the Hungarian language, making it available to many more people in the country, and providing an easy-to-read version for persons with intellectual disabilities. Now, slowly but surely, 18 months later, we are beginning to see some really powerful outcomes. The EU have been deeply embarrassed by the findings. Following a number of our own transparency requests for documents, we now know that the European Commission has halted over 165 million euros of investment to Hungary for financing of the group homes that I mentioned earlier. We understand now that there are intensive discussions taking place between the EU and Hungary, urging the latter to shift course if it is to continue benefiting from European aid. This is welcome, not least in part because this is precisely what my organisation and persons with disabilities in Hungary have been calling for many, many years. Much of these discussions happen behind the scenes without real involvement of persons with disabilities and their representative organisations. Nevertheless, the inquiry report has prompted an important shift in tone and a new glimmer of hope that Hungary may eventually start changing course. There are also some wider ramifications. Many other countries in Central and Eastern Europe are members of the EU and have similar systems of guardianship, along with high rates of institutionalization. Here in Europe, we have aging populations, meaning that many of our countries are inevitably having to plan and restructure for the future. And sadly, it's the old institutional forms of care, such as retirement homes, that remain at the top of the mind of policymakers. The CRPD Committee's report on Hungary, therefore, is all the more important, making it clear that all forms of institutionalization result in grave violations of the Convention and of the rights of children, adults, and older persons with disabilities. What does all this mean? Well, in simple terms, it means that the CRPD Committee is forcing governments and even the most powerful trading bloc in the world to reconsider and begin shifting investments that affect hundreds of thousands of people with disabilities in both Hungary and beyond. We have an authoritative decision of the UN, which we are now using in courtrooms in Budapest and in Strasbourg, demanding that individuals be released from guardianship. And it means that we now have numerous legal actions pending, challenging both Hungary and the EU when they continue to invest in institutionalization. Dear friends, in my closing remarks today, I must reflect how inspiring it is for us to see your own advocacy in Korea. And I fully support Ellen's remark that we need to hold hands across borders, even virtually, and stand in solidarity together. Although we are physically distant, I feel that we can learn a lot from each other. We are ready to provide our advice and support and solidarity as you move forward on this path. And we wish you all a very successful day today and beyond. Thank you.
Thank you very much. Thank you so much for showing so much interest and also solidarity to the movement here in Korea, and also providing us with the case examples on the systemic instances of abuse and violations. And I think that this would be very helpful for us, not just here in East Asia, but also in Europe. Now we'd like to move on to our third presentation. And for this, we'd like to hear from Ryu Da-sol, who's the Director of International Relations at Minbyeon, who's going to be talking about the issues after the ratification of the CRPD's optional protocol in Korea. Hello, my name is Ryu Da-sol from Minbyeon, Lawyers for a Democratic Society. It is a great honor for me to have this opportunity to present at the PyeongChang Disability Forum, and today I would like to talk about the Convention on the Rights of Persons with Disabilities and Optional Protocol, some of the legal issues that came out after the ratification. I'm going to follow this order in my presentation. As you can see on the presentation, first I'm going to briefly touch upon the UN human rights mechanism and an overview of the convention itself, but I don't think that this is quite necessary for this crowd, so I would like to skip over much of that and move into the legal significance of CRPD's optional protocol as international law and as domestic law. In particular, I want to talk about the implementation of these international human rights norms, such as the convention here in the Republic of Korea under our domestic law, and look at how this would impact victims, organizations, legislature, judiciary, executive. With the optional protocol, as already has been mentioned by our colleagues Ellen and Stephen, they've already illustrated the different case examples of the optional protocol. Just maybe providing the theoretical framework for this, I would like to say that the optional protocol, as it is understood, is a supplementary annex to the convention. So it's an international convention in and of itself. The current optional protocol that we are talking about can only be ratified by signatories to the convention. But as its name suggests, it is optional, so you don't necessarily have to ratify this. In the case of Korea, we are a signatory to the CRPD, but we have not ratified the optional protocol. By becoming a signatory to the optional protocol, we can have a stronger realization of the rights enshrined in the CRPD. So the optional protocol can provide itself as a tool for domestic compliance of CRPD in the future. We've heard different case examples from our international colleagues, and I think this would refer to the procedural aspects of the optional protocol. As has been mentioned, the CRPD optional protocol provides for communications and the interim measures. So for the communications, if there are any individuals or groups who feel that they have been violated of their rights, they can issue complaints or these communications to the committee. This is a quasi-judicial procedure similarly to litigation. The communications are very particular in that most of the positions are stated in written form. So their interrogatories and responses are all done in written form. And there are views and recommendations that can come from the committee, which do not have any legal binding effect. There's certain admissibility criteria that we have to comply with, and there are also some interim measures that can be brought forth by the committee. The communication process follows this order that you see on this slide and has been mentioned. The complaint or the communication is first posted, it is placed, and the secretariat goes through and reviews the communication. Then the CRPD committee would review and deliberate on the content of the communication, and this will be followed by a decision. Some of the eligibility criteria, as you can see here, are not very expansive. The optional protocol articles 1 and 2 outline the eligibility criteria.
Next, an inquiry can be initiated by the committee itself. When the optional protocol is ratified, if there is reliable information that indicates that there is grave and structural violations of the convention, then the committee may initiate its own inquiry without any communication submitted. So previously in the first and the second presentations, there were these inquiries by the committee. As for the UK, DPAC worked with and convinced the CRPD committee so that they would begin an inquiry. So it took 3 years for DPAC to convince the committee to initiate an inquiry. Like this, certain organizations may provide reliable information to the committee, or the committee may happen to find certain situations where grave and structural violations were found, then they will initiate an inquiry. So after the inquiry, the findings, comments, and recommendations will be announced. What is interesting here is that when a state party ratifies the optional protocol, they may declare that it does not recognize the competence of the committee to initiate an inquiry. So it is an option. This is the process of the committee-initiated inquiry. So there is obtaining of information, and inquiry will be conducted, and the findings will be announced. The case in the UK that was mentioned in the first presentation, there was mentioning about caution related to diplomatic relations. Likewise, when it comes to this committee-initiated inquiry, it will be all closed-door meetings. This is the eligibility of the inquiry that will be initiated by the committee. But this eligibility criteria are not very strict. So it does not require any formal petition. When the committee acknowledges that there was suspicious violation of the convention, then it may initiate the inquiry. Therefore, victims do not have to come forward. But what is critical here is that there should be enough evidence indicating grave and structural violations of the convention. Now, as for the ratification of the optional protocol of CRPD, I'd like to discuss the significance under the domestic law. Article 6, paragraph 1 of our Constitution stipulates that international laws and agreements or conventions ratified by the state government will have the same legal effect. And by ratifying the optional protocol, you can see that the findings and the recommendations will have similar legal effect. And the optional protocol will be considered as having the same legal effect as domestic law. But as for the aspect of legal enforceability, it may have some controversy. Because as for the comments and recommendations by the committee itself clearly states that these comments and recommendations are not legally binding, but because these are comments and recommendations produced based on the optional protocol that has a similar legal effect as domestic law, such comments and recommendations would need to be complied with and would need to be respected domestically. And comments and recommendations may include financial compensations or legislative or administrative measures. Therefore, if we do not take up and comply with these measures, then it may be deemed as a violation of an international convention. Now let's move on to various stakeholders involving the optional protocol. When the optional protocol is ratified, then it will have implications on the disabled persons in several ways. First of all, if there is a violation of the provisions of the convention, victims can utilize the optional protocol as a complaint process. And as for victims of violations, and if they think that their rights guaranteed by the convention have been violated, then they may go through and utilize available domestic remedies. However, if they fail to win in any legal cases or in any other measures, then these victims may go to the CRPD committee for communication. And when you look at the optional protocol, you can see that victims do not need any formal legal counsel. So any individuals who claim to be victims of such violations may go directly to the committee and send a communication. And there's no temporary prescription. Even though the committee may conduct an inquiry on a specific communication. If there's serious violation, there's no time limit as to when such communication can be filed. Now let's move on to the implication of the optional protocol on disabled persons or disability activist groups. I believe that such groups can utilize this optional protocol as a channel to drive fundamental changes. And as for an inquiry initiated by the committee, victims do not need to come forward, and it may not just be individuals or individual victims, but also groups of individuals that can submit a communication. And when the committee decides to initiate an inquiry, then victims do not need to be identified. So these offer some good opportunities to lead fundamental changes. And also disability rights movement groups and NGOs can continue to monitor the implementation of recommendations and comments by the committee, and they can share and disclose findings and recommendations. And after the optional protocol is ratified, the legislature would need to reflect the findings and the recommendations by the committee into the legislative process. Korea is a signatory of the convention, so any interpretations and implementations of the convention should be carried out by the government, and it is the legislature's responsibility to ensure such implementation. So the optional protocol can be referred to as a means to strengthen domestic remedies and protection mechanisms. Next, I'd like to discuss the implications of the optional protocol on the judiciary. After ratifying the optional protocol, the judiciary process would need to respect and examine the decisions by the committee. Currently, when you examine domestic court rulings, you may find that the CRPD or other UN conventions optional protocols have been reflected. And as for the state's responsibility for compensation, may have been reflected in the domestic judiciary process, but we have rare such cases. So we don't have a lot of such cases in Korea. For instance, we have, let's say, in 1995, there was the UN Freedom Committee, which ruled on the rights of workers. And at that time, the Freedom Committee ruled that there was violation of the freedom, the right and freedom, but the conclusion of this committee was ruled in the domestic court as not applicable in the domestic judiciary process. So it was an unfortunate court ruling. And I think it was 2019 or 2020 when there was a native English-speaking teacher, and this teacher filed a complaint to one of the UN bodies for settlement as an individual regarding racial discrimination. So there was a ruling in favor of him, and based on this ruling, he filed for competition from the state government. And in the first trial, the plaintiff won the case, so it was ruled final. This is a positive case. And after the ratification of the optional protocol, if such individual inquiries and recommendations are announced by the UN, then I really hope that the domestic judicial process would recognize such rulings by the UN body and reflect them in the domestic rulings as well. And I believe that the findings and the comments by the CRPD committee will provide a good motivation to revise and reform the judiciary process. And such findings and conclusions would need to be made public, and the training of judges would also be necessary. And since 2005, in the court official gazette, such findings have been announced. And finally, I'd like to discuss the implications of the optional protocol on the administrative body. The ratification of the optional protocol will motivate government administrative bodies to conform more closely to international human rights norms. Of course, international criteria may not be applicable as they are to all these different countries, and government policies may not be completely aligned with international norms on human rights. So we can, but we can apply international human rights norms in specific cases. So it is going to be a case-by-case approach where we will incorporate comments and recommendations by the committee in domestic policies. Also, the committee can provide some clarification and interpretation of the convention as it relates to the implementation of the convention itself. And in such cases, the government can provide explanations in written form to the committee. And as for the victims, they will also be given an opportunity to explain and convince the committee as to why such situations constitute violations of the convention. So in this process, we will be able to have opportunities to clarify on our understanding by exchanging our positions and views. And such exchanges would be informative and would help the administrative body to understand the convention. And if the optional protocol is ratified, then I believe that the government has to work hard on information disclosure. For instance, comments and findings of the committee will need to be interpreted, will need to be translated in Korean and announce them officially. And if inquiry findings are produced, then they will need to be distributed and promoted so that the general public can have a better understanding of such inquiries and their findings. Thank you for your attention.
Thank you for the presentation. It was very detailed in scope. We have to review the adoption of a special act and also to have some extended powers for the judiciary. I think that was very helpful in letting us know of the different work that we have ahead of us. We are broadcasting the session live online. We'd like to ask our online participants to also submit any questions if they have. Now we'd like to move to our panelists and hear what they would like to say in terms of the actual implementation. First, we would like to hear from Kim Sang-yeon, a director at DDASK, Disability Discrimination Act of Solidarity in Korea. Hello, ladies and gentlemen. My name is Kim Sang-yeon. I'm a director of DDASK. Regarding the optional protocol, which has already been mentioned by the different presenters, I would like to talk about how the implementation and the procedures should be done in a way that really protects the rights of persons with disabilities. For a very long time, we have continued to urge the ratification of the optional protocol for the Republic of Korea, but for a very long time, the ratification has not been done. These are some of the conventions and particularly the optional protocol that the Korean government has ratified. For example, the rights on civic rights and political rights in 1990 and CEDAW in 2007 and the rights for children, the first optional protocol and the second optional protocol have been ratified, but not the third optional protocol. This third optional protocol, particularly regarding individual complaints, have not been ratified, similarly for the same reason with CRPD, because of how the government says that it would be difficult to implement in a domestic law. And so the ratification for this particular optional protocol has not been had. Regarding this UN CRPD optional protocol, as has been mentioned by the other presenters, the ratification was done in 2008. It went into effect in 2009, but the ratification was done without the optional protocol. There was a reservation made by the Republic of Korean government on the Article 25 regarding the Article 25 about insurance, particularly life insurance, subscription rights. And this, the government claimed that might clash with domestic law, and therefore they reserve the right to ratify this particular article. Last year, on December 23, this reserve clause, the reserve provision, was pulled out. And once that was done, then this has also been chosen. This has also been selected as well. As has been mentioned, the optional protocol right now, we are almost nearing the end. There is only one final stage left remaining. Now let me move on to the procedures that are in place for persons with disabilities to engage in complaints. Now, for their rights complaints, these are some of the complaints procedures that we have in Korea. The National Human Rights Commission, for example. The National Human Rights Commission also has its own mechanism for addressing complaints and petitions made by persons with disabilities. And there are criminal and judiciary procedures in place seeking compensation and damages as well. So there are these civil and criminal procedures in place. However, this as well, 8 of the 11 commissioners at the National Human Rights Commission of Korea are legal scholars, so it is difficult for them to go beyond the scope of the actual legal statutory areas, and so it is difficult to go beyond that scope in many of the cases. Some of the other procedures that are listed here, for example, with the criminal procedures, the persons with disabilities would have to reach out to an attorney and etc. So these complaints mechanisms are not necessarily very accessible for persons with disabilities. The optional protocol of CRPD, however, it has the communications and the inquiry mechanisms. And this would not be very difficult to imagine because it's similar with the complaints mechanism that they have at the National Human Rights Commission already in Korea. This, however, provides a pipeline for persons with disabilities to address their concerns directly to the United Nations under the optional protocol, which is why it would be very significant for the Korean government to ratify the optional protocol. This would not be done with just a simple ratification of the optional protocol, which is why we need to continue to have these discussions and seminars, because there were many other conventions that I mentioned before, and although Korea has ratified many of the optional protocols to those conventions, we still do not have domestic mechanisms in place to allow for and enable the use of those different optional protocols, so we cannot really leverage them as well. So for example, with the optional protocol for CEDAW, we do not have a very strong mechanism for domestic implementation in Korea. So some of the conclusions in Korea were very conservative against international norms. And it is difficult for us to make use of these different mechanisms. And also for the Convention on the Rights of the Child and some of the other conventions, the optional protocols may have been ratified, but they are not really being put to use as much as we would like. So we would like to look at some procedures on what we need to do to try to make good use and full use of these different mechanisms. For the optional protocols, there needs to be support given to the individuals and the groups here in Korea to write the actual communications, because we don't speak the English language, first of all, so many of the individuals would not be able to write out their concerns in the way that would want them to, and also they're not familiar with the UN framework, first of all. So because of all these reasons and more, they need to receive support on writing the actual petitions and the communications. There needs to also be some support to gather and collect the relevant evidence and materials to support the claim. Furthermore, once the communications are provided, the whole process has to be also alerted to the complainant, to the petitioner, to the person with the grievance. So there needs to be some level of hand-holding involved throughout the entire process. So these are some of the different procedures that are needed as well, especially for the legal measures that the individual or group would have difficulty in understanding. And particularly when there is a conclusion that is given and the decision is given, but the individual or the group in question needs to see how the decision will be followed through and how the decision will be implemented. So this kind of a follow through and follow up kind of support should also be given as well. Because if this kind of support is not provided, then ultimately the individual or the group would have no recourse but to go to an attorney or to hire a lawyer, which is what they would do anyway if they were to go through civil litigation or criminal litigation, which is why in that case, this kind of UN mechanism would also not be accessible for the person with disability, which is why it will be incumbent upon us to provide the necessary support to these individuals and the groups. So to that end, we have to provide some level of procedural support, which is what I've mentioned. So who will be in charge of this kind of procedural support? How is the support going to be provided? And once the support is given and later the recommendation is laid out, who is going to monitor the implementation of the recommendation? I think there are about 3 views that have been given. So there could be an independent body that is installed to oversee this. I would like to say here that this is my own opinion. Many organizations of disabled persons say that we need to have an independent body, but I disagree with that. I don't think it would be easy to install a separate independent body because we tried to do something similar before with another piece of legislation, but within the different circumstances, it was not easy for us to install an independent body, and ultimately the National Human Rights Commission became the central authority, and the Ministry of Justice would be the authority to oversee the implementation of the decisions. So, although many organizations call for an independent body, it would be very difficult to install a separate body and allocate the necessary budget and resources. So, even if we were to urgently ratify the optional protocol, we would not be able to make use of it for many years because we would be busy fighting over how to install an independent body. And as I mentioned before, if we miss those crucial first years, it would be difficult to make use of the optional protocol mechanism later on. Second option is to go to the Ministry of Health and Welfare. The Ministry of Health and Welfare would probably be a party to many of these complaints. So for the individuals and groups, they are likely to lodge complaints against the Ministry of Health and Welfare. So in many cases, they would be a party to the communication. So it will be very awkward and difficult for them to be the central authority in charge of overseeing these different procedures. The last recourse would be the National Human Rights Commission. Again, this is my opinion. I think that it would be most appropriate for the National Human Rights Commission to serve as the monitoring body for the UN CRPD optional protocol, because this is what other international cases are like. If we look at other countries, their international human rights, their national human rights bodies are also responsible for these. The National Human Rights Commission of Korea should have the authority to carry out the implementation. And if the implementation is not carried out well, then they should be the body responsible for overseeing all of this. And to do this, we need to come up with a domestic law that underpins this. And once that is done, especially when it comes to implementation, when there's a recommendation or a decision made by the UN committee, then we would have to make sure that the implementation will be followed through to the end. The optional protocol is a very important mechanism. This is the only recourse that individuals and groups would have to receive a decision that goes beyond the scope of current domestic law. Korea's domestic law is not up to par compared to international laws. So, for example, we lack the most kinds of basic mechanisms. For example, we have a grading system in place that we have called for eradication, which has not been done. So if we want to have international level of protection for many of these rights, we have to continue to ratify these international norms and international treaties and conventions. We shouldn't repeat the same mistakes of the past, where we have ratified the optional protocol, but we were not making good use of the past optional protocol. And instead make sure that this optional protocol for the CRPD would be made full use of. We have to really be considerate of that, and I hope that all of these stakeholders would call for the right procedures to be established so that anyone can have easy access to this UN mechanism, and call for changes and engage in communications if they can. I think we have to continue to let our voices be heard. I think that these discussions, even if these discussions are over, I hope that we can always take an active interest on how the optional protocol is made and how it would proceed in the future. I hope that the optional protocol can be a very effective mechanism to protect the rights of disabled persons, and I hope that it will be established as a very necessary component in our human rights protection mechanism. Thank you very much.
Thank you very much. I understand that she supports various complaints processes and remedy processes, so I believe that she has a lot of work to do in the future as well. Now I'd like to invite Cho Gyu-bum from the National Assembly Research Service for his comments. Hello. I am very happy to be part of the session under 2022 PyeongChang Disability Forum. I would like to express my gratitude to all of those who are working for the rights of the disabled persons. The topic of the session is disability rights and UN complaint process. And I enjoyed listening to the presentations by Ellen Clifford and Steve Allen, as well as lawyer Lee Da-sol, and also Director Kim Sung-yeon. They laid out a lot of details about the complaint process, so I would like to make some additional comments to supplement their discussions. As you may know, CRPD was ratified in December 2008 at the National Assembly, so it has the same legal effect as a domestic law, but as Ms. Kim mentioned, one article of this convention may come in conflict with commercial law in Korea, which is about purchasing insurance policy. And so ratification was postponed because of this. And the optional protocol, which involves individuals' communications and inquiry by the committee, has not been ratified yet. In June last year, this optional protocol ratification bill was actually passed on the floor, and it was also passed at the government level. And I actually checked about this with the National Assembly, and on December 28th last year, it arrived at the National Assembly, and last year on December 29th, this particular motion was tabled at the Committee on Foreign Affairs, and this has been pending since then. And this Foreign Policy Committee has not been held yet. That is why it's been pending since then. But now that we have had the presidential election, I believe that the committee may resume its activities, and I hope that this would be passed through this committee. When it comes to the legal effect of international conventions on rights, Attorney at law Ryu Da-sol explained in length in her presentation that according to the Korean Constitution, any conventions and agreements and international arrangements adopted by the Korean government according to the constitutional process will have the same binding legal effect as domestic law. Therefore, the optional protocol, when it is ratified, it will be considered as having the same legal effect. That is one stream of thought. And of course, there's a minority thinking that this would not be subordinate to the domestic law. When you look at the Vienna Convention or overall international conventions on human rights and also the Korean Constitution, when certain protocol or convention is ratified by the National Assembly, which is a parliament of Korea, then it will have to have the same legal binding force as domestic law. Otherwise, it will be a violation of international convention. And in Korea, the optional protocol, if it is ratified, it means that the government recognizes the competence of the committee. So that is what is stipulated in the optional protocol. So it means that the Korean government, as a state party, a party to this convention, will have the obligation to comply with the recommendations and conclusions by the committee. As was mentioned previously, as for individual complaint processes, I believe that we need to put in place support mechanism. And to put in place a support mechanism for such processes, we may consider creating an independent body, or when it comes to relevant costs and mechanisms and processes, we may entrust the National Human Rights Commission so that they can function as a supportive body. And if there's any violation of the rights of disabled persons, we should help these victims so that they can have easy access to the complaint process. So we need to clarify on the judicial and other remedy processes. And when the domestic remedy processes have been exhausted, then individuals should be informed. They need to know that they can go to the UN for additional complaint process. And as was mentioned, we may utilize the National Human Rights Commission, or we may create a separate independent body for monitoring and support. Or some would argue that at the National Assembly, within the National Assembly, we may create a standing committee. Of course, human rights issues are concerned with various standing committees, partially, but one idea is to create a separate standing committee at the National Assembly that deals with human rights issues. But realistically speaking, this issue is not extensively discussed at this moment. And another idea is to create a subcommittee under the Judiciary Committee of the National Assembly, because the National Assembly Judiciary Committee would examine any conflict or overlap of legislative bills based upon the existing legal system. So that is another idea. And Director Kim's idea about creating an implementation mechanism is what I support as well, because we need a follow-up legal measures. So we can utilize a legislative process. We can create a law, or we can revise the existing criminal law or a commercial act to allow filing for financial compensation for such victims, or we may create a separate law that will provide a legal basis for additional compensation, or we may also assign responsibility to the Ministry of Justice so that such implementation will occur. And in carrying out these measures, we may create an integrative law, or we may have, in other words, we may have a separate law that governs the procedures of the implementation of decisions by the committee, or we may include or revise some of the existing laws to ensure implementation. Also, regarding the provisions, so Articles 6 and 7 are about an inquiry that can be initiated by the committee based on its competence. Along with individual communications, inquiries can be initiated by the committee to enforce the protection of the rights of disabled persons and compliance with the convention. So if there is reliable information that indicates grave and structural violations of the convention, then the committee may initiate an inquiry and requests information from the state party concerned. So we have an act on the protection of the rights of disabled persons and their remedies. We may revise this act to include or incorporate the optional protocol processes. And also, when it comes to regulations regarding the implementation of the recommendations and comments from the committee, we would have to also include them. And when the optional protocol is ratified, the follow-up measures will need to be taken, and we will also need to promote awareness on this particular optional protocol to the general public. So we may make such information publicly available by using the official gazettes or public bulletin boards or the websites. And in addition to such promotional activities, I think we need to educate our citizens. And we also need to get input and feedback from civil society groups. So these are my comments as a panel member. I really hope that today's discussions and presentations will make meaningful contribution to advancing the rights of disabled persons. Thank you.
Thank you very much. Even despite the COVID-19 situation, we have many people joining us online, so thank you very much. So thank you for informing us about the situation at the National Assembly and how we were able to try to create some consensus at the national level, and that has provided us some food for thought. We'd now like to move on to our final panelist, who is An Eun-ja, the Director of the National Human Rights Commission of Korea, the Disability Rights Division. Hello, my name is An Eun-ja. I'm from the National Human Rights Commission. It is a pleasure for me to participate in this very meaningful discussion right before the ratification of the optional protocol. I really enjoy listening to the presentations and to the different comments made by the panelists. The other panelists have said that they would like to expect certain roles for the National Human Rights Commission. Well, I would like to discuss the same kinds of dilemmas that we have at the National Human Rights Commission and what we should do after the ratification of the optional protocol. We are currently receiving complaints and trying to provide aid and relief to the individuals and groups who bring complaints to us on violations to their rights. We are also the monitoring body of relevant international treaties, so we provide that monitoring expertise here in Korea. Also, for the ratification of the optional protocol, which we are discussing right now, for the last few years, we have continuously urged for the ratification of the OP, and we have released statements to that end, and we have continued to explore our role after the ratification of the optional protocol. We have had roundtables and various discussions on that. I cannot say that we have come up with a conclusion regarding our role, but we are looking into what possible roles we can play, and we have to try to reach a conclusion. With the comments that I want to share with you today are some of the positions that our division has made in the past regarding the role of our commission after the ratification of the optional protocol, but this is not the final position of the commission. For us, the legal statute, the relevant law for our foundation has several articles, and of these, Article 19 would have to be amended slightly to talk about our roles and functions. In fact, we tried to do the same for the ASEM Center, which was established not long ago. However, we were unable to do so, there was a separate body set up to oversee the operations of the ASEM Center. For the administrative support, translations, and sending and receipt of different legal documents. This kind of support is something that our commission should provide, but if there is no legal basis for our functions, then it will be difficult for us to expand the scope of our support, and we would just play a supplementary role. There needs to be a fundamental review on whether an organization such as ours would try to provide a legal recourse for an individual and their complaints. Right now, the Legal Aid Association provides legal support for individuals and groups who seek to petition these different mechanisms. So perhaps it would be the Legal Aid Associations who would try to provide that kind of support. And in many cases, these different petitions regarding the rights violations of disabled persons sometimes, in many cases, make their way to the Supreme Court. And we also provide support in that process. When there are recommendations made by the Commission, and if this can be carried out by corrective order, that would not be necessarily problematic, but in some cases, the Commission would say that this particular case is not a case of discrimination, but then the plaintiff would argue otherwise, and this would make its way to the Supreme Court, and then the Supreme Court would find that it was a violation. So if that is actually a kind of case that we can consider that would occur with a UN mechanism, is that also something that the Commission should continue to support, is the fundamental question. And also, there is the issue of the budget, the funding. The Commission is not a policy body. We don't formulate policy and execute policy. So if there needs to be this kind of policy support, perhaps it should be up to the relevant ministry, the line ministries, to provide that kind of support. Because we are a monitoring body, once the OP is ratified, the Commission should provide some kind of support to the individual or the plaintiff organization. There are many voices calling for that, but instead of that kind of support, when there is a final decision made by the UN committee, the Commission can monitor whether this is implemented properly in Korea and continue to urge the government to work on the implementation. This could be the possible desirable role played by the Commission. And after the ratification of the OP, as has been mentioned by the other panelists, a newly enacted kind of act on the protection of the rights of disabled persons or any other kinds of new statutory activities would likely help to supplement these efforts. So, going forward, The Commission will continue to deliberate different kinds of options that we should think about in terms of the role that we will play after the ratification of the optional protocol. I hope that all of the stakeholders will continue to take an active interest in this issue and continue to provide us with good feedback so we can have these in-depth discussions. Once the optional protocol is ratified and it is established, and if there are any shortcomings or limitations regarding domestic law or the protection of rights in Korea, and there are some persons with disabilities whose rights are infringed, hopefully they can seek remedy and relief, and that would be excellent. That would be great for us. If you can provide us with much feedback that we should consider at the Commission, that would be helpful, and I would take it back with me to the Commission's offices so that we can have more in-depth discussions. Thank you.
Thank you very much. So there may be various complicated situations involving violations, and I hope that the National Human Rights Commission will continue to ponder upon this issue. So we heard the last panelists, and there's no question from the online audience. I wonder if there's any question from the floor. Hello. I am Choi An-byul, working at the Korea Disability Forum. I would like to express my thanks to all the speakers and the panel members, especially those foreign speakers who are our colleagues in promoting the rights of disabled persons. I hope to be able to see them in person when the pandemic is over. My first question is to Mr. Cho. He discussed various ideas as to how we can enhance implementation of the convention, and there were several views summarized by Mr. Cho. For instance, the individuals may or victims may be given right to file a lawsuit against the state or against certain parties. But in your view, Mr. Cho, what will be the most viable option or idea that can be implemented? My second question goes to Stephen Allen, who reported on the Hungary case. Recently in Validity Foundation, they also did a complaint or communication to the Committee Against Torture. And I heard that this woman who was tortured and received cruel treatment was filed, and it was ruled against the convention, and the committee made a good finding. So it is not only the CRPD, but other UN mechanisms that you've been utilizing at your foundation. So can you briefly talk about this particular case as well?
Yes, so I would like to respond first. I provided different kinds of options on the enactment of different legislation, and I think that the UN's treaty organizations, the legal effects of this, as Ms. Liu has also mentioned in a presentation, there is some of the understanding that this should be seen as a legal piece of, it has legal effects, and some who say that it actually doesn't have legal effects, or some say that it's also kind of a reference that we should think about. If we were to recognize that it has legal binding, then we can provide support to that end. So, for example, the international body's finding or the decision will be directly translated into the domestic implementation and provide remedy to that extent. But some might call for a more specific and more explicit remedy mechanism to go in tandem with this. For example, which is what I mentioned before, in the criminal cases, there could be a retrial, and in the civil case, there could be a mechanism that ensures the plaintiff to seek a compensation or kind of damages from the state. So this is something that some people have said. So there are different opinions here. I am not in a position to say which position is right or wrong, but I can say that I am part of the National Assembly's legislative research arm, so we can try to provide a research looking into the pros and cons of these different arguments, ultimately so that the decision makers can make an informed decision. It is difficult for me at this point in time to provide a strong answer in either direction.
네, 이어서 스티븐 앨런 답 부탁드립니다.
Yes, thank you very much. As the person from the floor asked, validity, in fact, utilizes the entire range of individual complaints and inquiry procedures that exist under the UN mechanisms. So the complaint, I think, that was being referenced here was a relatively recent decision of the Committee Against Torture against Slovakia, whereby that committee, and this really is a first, that committee recognizing that the placement of our client in old style netted cage beds as a form of restraint amounted to torture under the Convention Against Torture. And so this is a really positive development in a sense, where disability rights issues are actually being addressed transversally under the jurisprudence of other committees. I would say that we also have complaints pending before the CEDAW committee as well on the rights of women with disabilities. We also have complaints pending at the Child Rights Committee as well. So I think it's a very important point to make that it is not purely the optional protocol to the CRPD that can help advance disability rights. And of course, we strongly advocate for organizations of persons with disabilities to utilize the full range of systems. And I think in Europe, we're quite lucky in a sense. I say we were lucky until yesterday, I'll come on to that, but we're lucky that we have a number of domestic regional complaints mechanisms that we can use, including at the European Court of Human Rights, the European Committee for Social Rights, etc. Whereas I understand this is not the case in Korea, and so you do need to be creative in looking at those international remedies that are available, not purely under the conventions as well. I mean, I would remind everyone there that you can also address issues to the special procedures and mandate holders under the Human Rights Council, including the Special Rapporteur on the Rights of Persons with Disabilities and others, who can often respond much more quickly, in fact, than the UN treaty bodies. I only say we are lucky in a sense in Europe because I understand yesterday that the Russian Federation withdrew from the Council of Europe. This is a very, very concerning development for all of us, and not least, I would say, for the 1.2 million people with disabilities detained in nameless institutions across that country. So yes, I think the point is very well made.
Thank you very much for that. I would like to thank all of the panelists and the presenters for their in-depth discussions and also from the questions that we received. Thank you to the panelists for staying with us until the end. The optional protocol for the CRPD is an accountable kind of promise that we are making. And we hope that through this, that we can continue to spread the awareness of the rights of persons with disabilities, not just here in Korea, but across the world. Thank you.